many other things. And I'm sure you will all bring from his wealth of experience and knowledge today. We also have Mr. Inam Wilson, Mr. Osobeku. We're expecting that at some point, the president of the National Industrial Court, my Lord Justice Kanyip, would join us at some point this afternoon. We're also expecting Mr. Okeo Memo to join us at some point. I'll very shortly be yielding the floor to Mr. Falabi Kuti, who would generally set the stage for what today's presentation would look like. And we expect it to be very interactive. Do please send your questions to the Q&A box for ease of reference. And so my pleasure now to invite Mr. Falabi Kuti to set the stage for today's presentation. Thank you very much. Falabi.
Thank you. Yes, a very good afternoon, everyone. And let me start by thanking Tobina for having us come back on this, the third day of the Employment Law Series session that the ICLE has thoughtfully put together.
Falabi, I think your volume is low.
Okay, all right, no problem. All right, let me check that here. Okay, all right. So what I was saying is I joined you to say welcome to everyone to the third day of the Employment Law Series that we've been having since the 1st of April. We've had two previous. Is it better now? Am I loud, clear? Can you hear me?
Yeah, hello? Better, much better. Thank you.
Much better.
Fantastic. Oh, fantastic. I mean, you didn't want me to use this guide initially, so that's what has come to it. Okay, so I was saying that so this is the third day. In the two previous sessions, we had speakers, the rich array of speakers coming to treat different topics within the new labor law jurisprudence. And so what we've thought of for today, which is the third and the final session, is to make it a little bit more interactive, have like a conversational style of presentation. There are question and answers there are questions that will be posed, specific questions that will be posed to the speakers and or the panelists. And we also expect as you go along that your questions, especially the ones that you think might not have been answered in the last two sessions, or new ones arising from within the context of what we're discussing, if you leave them in the chat box at some point, in fact, as we go along, because that's really what this session is about for the next 2 hours that will be here. So a very good afternoon again, you're welcome. And without much ado, I think that this is 1:05. I need to just start. Yes, Tobina, thank you for making the introduction. I do not need to go through that again, but I know it's okay him. I just need to be sure that I haven't heard from him.
Yeah, yes, I'm here.
Fantastic. Well, a very good afternoon. A very good afternoon. Fantastic.
Good afternoon, everybody.
So primarily for the two speakers or panelists for this session are Mr. Godwin Omaka, SAN, and then Mr. Okechukwu would also be speaking on, would also be addressing the various questions and that we will be posing. And then we also expect that if you have other questions, we'll also treat that. So without much ado, let me start now with the questions. And I think the very first one we'll go to, okay. I see that, there's a new labor law jurisprudence. And then let's start from one of the more radical views that we are having to contend with, and which is that an employer cannot terminate without giving a reason. The question I ask is that, can an employer terminate without giving a reason, or would there be a cause at every point in time?
Yeah, thank you, Lenese. See, this is an issue that has generated a lot of controversy in recent time, particularly because the traditional view, the common law view, which we are all used to, appear to be under threat by recent decisions of NIC. Generally, we know that the right to hire and fire resides with the employer, And we often also hear the notion that an employer, you can't force a willing employee or an unwilling employer. So if you take all of that into context, you now see that in recent time, the NIC, particularly when it comes to employment that relates to the banking sector and some other sectors, will appear to hold the view that you can no longer terminate without reason. In fact, the decision in Aloysius, which is a recent decision of the NIC, would even appear to extend it beyond the banking sector. And in applying Convention 158 of the International Labour Organization, have come to the conclusion that you must not just give a reason, but it must be a reason connected with the performance of that employee in his work. Not just any reason at all. That reason must have to do with that employee's ability or the performance of that particular task he's given to do in his place of employment. For example, I don't think it will be appropriate to say that because somebody has lost one of his legs, he can no longer work in a law firm as a lawyer, for example. So it must be reason connected with his ability to perform the task for which he's given. There's a decision, Ogbebo and Erickson, which I was counsel to the claimant. It was said last year, Judge Orji actually held that terminating an employee on the basis of service no longer required without giving any other reason is an unfair labor practice. And she held so in that case. So I think presently now, it is safe, following the decisions of NIC in recent times, to conclude that an employer owes an obligation to give a reason connected with the performance of the employee in the work he was assigned to do.
Thank you very much for keeping it short and incisive. And I think you covered it. And I can assure you that the related question that I will come to, still on that giving the reason, or whether it should always be related to the reason given when a disengagement comes to be, and how you probably think the Court of Appeal will look at this and seen in the context of, the traditional common law cases that went on to the Supreme Court, that decision from the Supreme Court that still get to adjudicate at that level. But like I said, I'll come back to that. So I'll go to the learned circle now, and then my question, is that you would agree with me that there is today a clash of content rights. The student employee approaches the NICF for the that has been terminated, and the employer who is at loss as to why the courts should question his power to discipline staff or bring a master-servant relationship for no reason at all. So the question is, do you agree that the NICF is balancing the rights? Do you agree that the NICF is balancing the rights doing its work? Or as is commonly or popularly believed, is unfairly tilted in favor of them? What are your thoughts on this? Do you think, looking at it from case law analysis or case law perspective, do you think that overwhelmingly industrial court is really balancing the rights, or they are popularly unfairly tilted in favor of the employee? Let us see, Komaka.
Thank you, Afolabi, for that question. That's a very good question.
Yes.
My take is that as a lawyer, and as one who loves statistics, I like to be guided by some empirical data as to the decisions of the NIC in resolving this particular issue. I would have loved to see data as to what number of cases the NIC has held that the termination of the employment of an employee for any reason or no reason at all, or applying international best practice and saying that, look, you have to terminate for reasons. I would have loved to see the comparative data to know the numbers. But be that as it may, based on the feelers, indications we are seeing from the NIC as to how it is ruling on this issue, I think the preponderant view has been that the NIC, like the last speaker said, has tried to apply international best practice and international labor standards based on the third alteration and section 7.6 of the NIC Act to hold that an employer must give reasons, not only reasons, justifiable reasons, which he must also prove. So at the end of the day, I think we have seen a departure from the old common law rule to the current position. And I think in that regard, the NIC is really balancing the stakes for the employees. Because don't forget, it is the employees who go to court many a times. It is not the employers. It is the egregious conduct of the employers in terminating the employment relationship of the employees that take them to before the NIC. And so when they get to the NIC, what we find out more often than not in the pronouncements of the NIC is that it has shifted from the old common law position, now applying international best practices, international labor standards to say that, look, you can't terminate for an employee's appointment willy-nilly. You must give reasons. Not only must you give reasons, you must prove those reasons for you to be able to terminate. I think we saw that play out in one of the decisions of the NIC. I think it was the case of Duru versus Skybank, where the former president of the NIC, Adejumo, actually said that Duru's employment was terminated by Skybank on the grounds of misconduct, and Adejumo held that reasons has to be given, not only given, but that that Duru had a right to contest the reasons that were given. Not only the reasons were to be given, that he had a right to challenge those reasons as far as they were given. So in a nutshell, my view is that the NIC is doing a good job. It is balancing the rights. Of course, employers will complain. It is only natural that employers will complain. But employers must understand that the world is now a global village, and Nigeria cannot be isolated. Our employment and labor practices must conform to international best practices and standards. So at any time, employers who are exercising rights of termination in contravention of international best practices must be held accountable. And I think in that respect, the NIC is doing a good job of balancing the competing rights between the employee and the employer.
Okay, thank you very much for that, Lenesuk. And as you spoke, I just kept thinking of the resultant's position, as we often see play out at the industrial court, where the court finds that unemployment has not been properly terminated or brought to an end. Because, I mean, take for example the reason not given, and then the court finds that the employer is liable for wrongful termination. And just before I go back to I just think I should ask you this follow-up question, and it relates to what is the resulting damages that the courts usually award. I mean, the quantum that falls from it, and the question around that will basically be that I mean, once upon a time, the position used to be that a minimally fixed quantum of damages for wrongful termination would be what the courts would have ordered or would have given in, as the relief, as the relief, and then that position appears settled almost to the point where I recall that there was a decision of the Supreme Court where the Supreme Court had even gone further to issue a stern warning to lawyers that, look, if there's any area that is settled in law, I think this area is one of those settled areas that once an employment has not been properly terminated, the quantum of damages that can be given is what ordinarily should have been given. Let's say the notice or would have followed a proper procedure. And in that while, this particular decision that I was referring, or that I'm referring to, Kuli Oshisoya and Africa, and I'll read briefly what the Supreme Court said. The Supreme Court had to warn Ogwagu GSC said, and I quote, "I wish to say with the greatest respect and humility that if in future any learned counsel who is aware or ought to know about these family established laws on master-servant relationship and bring this type of frivolous appeal up to this court." Now, in that case, the appeal was testing the quantum of damages. But the Supreme Court felt this is a fixed area. I think in the future, a counsel brings this sort of appeal to come and test this similarly settled area. That counsel may expose himself personally to the court awarding costs personally against such a counsel. Now, that decision was made in 2001. Of course, a few years down the line, Supreme Court maybe just didn't foresee that, well, there will be this third alteration or this revolution that the constitution of the country would actually witness, and then a provision will be there where an industrial court is created as a court with exclusive jurisdiction on labor and employment matter. And amongst the power given, especially in his Establishment Act, is that it can depart from common law principle, where it feels that common law does not suffice, apply equity, the principle of equity, and add additional damages. I mean, award damages as compensable damages as a court may deem fit. Now, that has led us to a new era where you hear such compensable damages to be as high as maybe 2 years' salary, 5 years' salary, and all of that. So the point asked is that, do you think this is good for labor and industrial relations? And will it make for certainty of the law as for future cases? And in some cases, the court could award 5-6 months salary. In some other cases, it doesn't appear as if there's fixed quantum. It would depend on what the court will say is case-by-case basis or case-by-case analysis. And the question I asked is that, okay, let's relate it within the context of the principles of the certainty of the law, what the courts are doing, judicial state, and all of that. Do you think it makes for certainty a situation where you don't have a court that can award as much as 2 years salary as compensable damages for wrongful termination, or 5 years, and then the list goes on and on? So let me hear your thoughts around that.
So, Afolabi, a very good question. And I wish my Lord of blessed memory, God bless his soul, Ogwagu, had a crystal ball at the time he gave his decision in Osisaya.
Yeah.
You know?
Yes.
Like you rightly said, he didn't know the third alteration was coming, and he didn't know the NIC Act was on the way as well. Section 76. You know? So, I mean, to go straight into your question, the point is this. The NIC is actually applying the principle and has set the standard. Let's not forget that a claim for compensation most times is a claim in the realm of special damages. All right? Now, it is based on the employee's salaries. It is based on his emoluments. All right? At the end of the day, it is what you are able to prove that the court will award. Of course, wrongful termination can also cause emotional stress and psychological pain, and that will fall within the realm of general damages, which the court now has a discretion to award. Where am I driving to? I'm saying that there is a certainty in terms of the principle, right? In terms of the principle, in the sense that the NIC, as we have repeatedly said, has said in terms of quantum of damages for wrongful termination, it has moved away from the concept where the quantum will be limited to the amount the employee will have been paid as his salary in lieu of notice. That is, the actual amount he would have been paid if the employment had been properly terminated during the period that he could not work. What they are not doing is giving appropriate compensatory damages. You see, 2 months, like rightly said, 3 months, 5 months. As long as you can prove that, they move away from that principle. I mean, a good case is the Maya versus Incorporated Trustees of Clinton Health Access, where the NIC held that termination of employment on grounds of pregnancy is wrongful and will attract the award of heavy punitive damages against the employer. So in that case, her employment was terminated on the ground of that she was pregnant, but the NIC awarded huge punitive damages against the employer. So the point is that the NIC has set certainty in the law. The certainty is if the employment is wrongfully terminated and the employee can prove his entitlement to his emoluments, what have been paid, then he will get it. But the amount will vary on a case-by-case basis because, of course, not all contracts of employment are the same. They contain varying terms and conditions of employment. But one area I want to talk about, and which I think is novel, is the question of damages that have been awarded for stress, emotional and psychological stress.
Yes.
Because don't forget that an employee whose employment will be wrongfully terminated goes through a lot of psychological and emotional stress. And before now, under the old regime, there was no compensation. But what we are beginning to see is that the NIC is beginning to say, no, even for when you wrongfully terminated, apart from the element of the special damages, which is the salaries, the emoluments that have to be proved, they will compensate for emotional and psychological stress. In fact, the Court of recently, in the case of Sahara Resources Limited versus Olawumi Oyebola, upheld the decision of the NIC that awarded 2 years consolidated base salary as damages in a case of wrongful termination of employment. So we are beginning to see that even the Court of Appeal. Oh, sorry. Can you hear me now?
Yes, I think it's better. I can hear you. Yes, I can hear you. Please proceed. Oh, no, we can't hear you. Hello? I think we cannot.
Can you hear me now?
Yes, you can. Yes, I can hear you.
Okay, so we can even see that even the Court of Appeal, which is the final court in employment cases, have endorsed the decisions of the NIC in the Sahara Energy Resources case, when the Court of Appeal awarded 2 years consolidated base salary as damages in a case of wrongful termination of employment. Now, the point is, based on this, the old principle that the Supreme Court stated under the common law, they've all fallen away, they've all fallen apart based on the third alteration and Section 7(6) of the NIC Act. And in view of the decision in Sahara Resources, I think the new dawn for employees in terms of quantum of compensatory damages.
I actually share the same view with you that, I mean, it's a kneel down in terms of compensatory damages. But maybe one area that I think the question might not have addressed is how this varying position or varying conditions taken into, I mean, varying compensatory damages, even in some cases, in two identical, similar factual matters coming before the court. And I'll give an example. One of the cases that the industrial court made a decision on last year, which I struggled with the award of damages. And that's why I say that there may still be a need to look at it closely to be sure that you can say it makes for certainty. You go into court, you can always say that on this set of facts, this is what we are likely to get. And the case I was going to refer to perhaps prove that point is Oyayero, British High Commission. It's a judgment given July 28, 2021 by my Lord Honorable Justice Bakoba. And in that case, what I would say is double compensatory award played out in the sense that at the end of the day, the court awarded 3 years salary as compensation, 3 years salary as compensation for wrongful termination of the defendant's employment with the British High Commission. And within the same breath, also awarded 2 years' salary as compensation for unlawful labor practice. So on the one hand, British High Commission was now made liable to pay for almost 4 years. 3 years, like I said, for wrongful termination, 3 years salary, equivalent salary for wrongful termination, and 2 years for unlawful labor practice. And then reading through facts, it's the same fact that donates the relief that is under the head of 2 years salary. It's still the same set of facts that donates what is called 3 years for unlawful labor practice. That's double compensation we do. Can this be said to be part of what the industrial court is doing, or is set up, or will be doing, or will be looking at? And then, do you think there are rough patches that perhaps there's still a need to look into that issue of damages? I'm sorry to take you back on this, and I'll jump right to the next question. Yes.
I think that's a rough patch, and you will not find that as an isolated case. But the good thing is the Court of Appeal is there to clear up this, to provide more clarity for us. In this instance, like you said, based on the fact on the Ogoshaki case, right? Yes. I think there was some double compensation in that regard. And I believe that if it is taken up on appeal, the Court of Appeal may have to intervene.
Fantastic.
And put that right, yeah. And so, yes. And that's why we talk about allowing our courts to develop the jurisprudence. Yes, in the course of doing all of this, there will be few mistakes here and there, but let's not lose sight of the overall objective of compensation.
Correct.
And the fact that in the majority of the cases, it appears that the NIC is getting it right. Yes. And of course, when we have these few cases, then of course the Court of Appeal is there to clear it up at the end of the day. Right. So I think that's one particular case where I think perhaps some intervention or comment from the Court of Appeal will throw more light on it for us.
Thank you very much. I mean, just to remind the participants that please, you can leave your questions, go to the chat box, leave your questions as we go along. This is a question and answer session, and then we have the panelists, those who were the panelists on the other 2 sessions before now, to take on some of the questions. As we have 2 panelists for today, as well as the others that I mentioned also in attending this and are ready to address all the questions today. Now, okay, let me go back to Mr. K, and then my question is a pointed one, go straight. Are employers obliged to give former employees work reference? Bring it home. A man worked with XYZ company, and then one day he received a salary today, then the following day it didn't turn up. Then 6 months down the line, ABC company writes to XYZ that, oh, do you know Mr. Anonymous? Mr. Anonymous says he worked with you for 2-3 years and all that. Can we get his reference? In this circumstance, or generally, is the employer obliged to give former employee work reference?
Yeah. Thank you, Leonard. Yes. The way I will approach the question, you give a specific example. That specific example, I will readily answer yes. A prospective employer is already asking you for a reference.
Yes.
And we all know that when a prospective employer asks for a reference, it usually will have an effect on the employment being offered to the employee. So likely, a refusal to give that reference or a dishonest or inaccurate reference might affect the chances of that employee securing that employment. So clearly, there's an obligation to give reference in that instance. But generally, a lot of decisions of NIC will say there is no general obligation to give reference, but when you do give reference, it should be accurate and fair. However, there are decisions like the Muigwe case and Fidelity Bank that will appear to take that position clearly that there is now an obligation. Because if you look at what is happening around the world want to bring international best practices into play, you understand that globally, employers are required to give work reference in most of the instances. If you talk about Nigeria, like in some of the cases, like the Mugbe case that involve Fidelity Bank, in the banking sector, where you fail to give reference, it will definitely affect the employee's chances of securing the future employment that is being offered to him. And where such refusal to give reference leads to a denial of that employment, the former employer will be exposed to payment of damages if the matter were to be taken to NIC. Then there is also other sectors. I have had experience of a law firm. A lawyer left a law firm and moved to another law firm, and that law firm required a reference. And when that reference came, it discloses some misconduct on the part of the lawyer who was looking for a job in the other law firm. And on that basis, that person was denied that employment. So I want to agree that the general trend would be, particularly on request, when an employee has requested a reference, that the employer will have an obligation to give that. I mean, when a prospective employer have requested a reference from a former employer, there will be an obligation to provide it. And the reason is because it will affect the chances of the employee in seeking future employment, and also because there is an obligation under the law to give an honest, accurate reference of the person's work behavior while he was in your employment.
Thank you very much for your for the very incisive response to the question. But let me just ask a follow-up. Number one, box, Michael has asked that those reference needs to be positive. So you'll be addressing that. But in addition to that, let me go back to the Kelvin Nwangwe's case that you referred to. Indeed, the position, like Riley stated, it will depend on, there was no general obligation. No general obligation, it will depend on the contract of parties. And the employment be a species of a contract. One would have expected that if it was that important, it would have been reduced, or it ought to be reduced into the contract of employment, or in addition, the workplace handbook. I mean, one of those two things can be looked into. So the way is not included. The takeaway from one way is that there is now an implied obligation. It's an implied obligation on all employers that must give. And I don't think that is stretching it, that if it was that fundamental, shouldn't it be the contracts that will speak it, as opposed to introducing that or stretching that to be an implied term of an employment contract? Do you agree that that might probably be overstretched? It was a fundamental term. It should be expressed. Do you agree?
I want to agree with the position that it should be an implied term. And maybe that is me being a pro-employee, even though oftentimes I find myself defending the employers. Yeah. But people do not require work reference just for fun. Yes. So the same way, because the old position was that you are not obligated to give this reference, but when you do give it, make sure it is fair and accurate.
Yes.
But in the present world of work today, people, prospective employers request for reference because they want to get an idea from the former employer about certain things about that employer. It is this reference that gives either a positive background or
yes,
provide the kind of assurance that a prospective employer needs in order to conclude an employment contract. And I can't remember exactly, but I've come across literature that talks about where a prospective employer gets has failure to disclose in full what you ought to have disclosed in this reference, and it misleads a prospective employer. On the other hand, in Nigeria, we've had to deal with cases where the employer, in giving this reference, makes reference to issues that the employee was not even aware of. There were, maybe you have some kind of issues with that employee, which you never brought to the attention of the employee. Maybe there were some investigations that were being carried out, which was never escalated and the employee was not aware. Maybe there were issues, things you believe the employee didn't do right. He was in your employment, but these issues were never brought to give you an opportunity to respond. And when a reference was requested, you mentioned these issues in the reference. The court have held that it is an unfair reference. So if you look at the importance and the role that these references do play in the life of an employee who is seeking employment elsewhere, I think I agree with the decision in Wigwe that it should be an implied term of the contract.
Okay, I thank you very much. I'm going to ask the learned Omaka to, bear his own thoughts on it. And then I look pointedly at the question that, to the extent that it appears to be a very fundamental term, that can even, looking at the example you just gave, that can even throw the former employer, open the employer up, the former employer up to the grim prospect of litigation. So take, for example, employer or the former employer, in giving the reference, thought was referencing what really happened, by which the former employee says he had no idea or he didn't know actually happened in the course of his work. And just because that is reducing to the work, to the reference letter or the reference for whatever shape it comes, the prospective employer or maybe the new employer desires to take that into consideration in bringing the employment to an end. The employee, in this case, can bring an action against the former employer for with his contract. So to that extent, don't you think, Leonard Silk, that that term shouldn't be implied? So it should be, again, it's talking about balancing contending rights. An employer doesn't want to be in a situation where it gives a reference and then is perhaps confronted with a litigation at another time in relation to it. It's okay to say it must be fair and accurate, but it was being fair and accurate, not trying to mislead. He's gone through the file and he remembers this, he puts it in the worker frame. The new employer acts on it and the former employer is sued. And to that extent, in drawing up the contract of employment, employer reasonably foresee this sort of ugly situation and says, well, I will not make this the term of this contract, and is neither not in the employee, the workplace handbook. So how do you protect such an employer who does that? And at the end of the day, the court says that obligation is an implied obligation. Whether or not you put it, the employer can, the former employee can bring an action or can take you to court, like happened in the Wigwe's case, for failing to give work reference. Talking about balancing the right, Silk, do you think the right is well sufficiently balanced?
Let me approach the question from two angles, right? Based on Wigwe. First, a contract of employment, as we all know, generally, more often than not, do not contain that clause that says, an employer is mandated to give a reference, generally. But in some cases, it does, right? And in those cases where it is contained in the contract, then there is an express obligation on the employer to give the reference. That's it, now, in those cases where it is not contained, such a clause is not contained in the contract, I think that's where the Wigwe case comes. The NIC has read into the contract an implied obligation to say, look, yes, it may not be an express term of your contract, but you have that obligation. And now, where does the obligation arise from? That obligation is an offshoot of an employer's obligation not to damage the employee's future employment prospects by harsh and oppressive behavior or by any form of conduct.
That is why it says, and that is why it says, then give me the latitude not to say anything.
Yes, right. But I think the issue now is in defining the contours of what that obligation ends. Because, yes, so that is where potentially the employer is exposed to liability. If he goes ahead to give a reference that is either unfair or misleading, even if he honestly believes it to be true. So there's a standard that has been set. And so that can expose the employer to a claim for either defamation or negligent misstatement or malicious falsehood. So it's a very delicate balance, all right? But I will advise all employers, and this is being on the side of the employers now, to say that, look, how you draft and couch the reference is very important in view of the implied obligation that has been imposed by Nwigwe. So you must ensure that the reference is carved in such a way that it does not damage the future employment prospects or even the personality of the employee. So for me, I mean, those are the two areas I will look at it to say, first and foremost, if there's an express provision in the employment contract of employment, then there's an express obligation on the employer. And where there is none, then there's an implied obligation on the employer.
Thank you very much. And let me go to the next question. And I would like your thoughts, and I'll throw it to Oke as well. And the question relates to, I mean, it's a common scenario that I see in the world of work. Can an employer proceed to terminate or determine an employment contract on a disciplinary issue or finding what's the, or finding of a misconduct, even when the prevailing facts also disclose a crime, an apprehension of a crime that is being investigated by the law enforcement agent or being prosecuted in a law court? So that is, can the employer will the mistake even when the criminal prosecution is yet to be concluded? Can he? And so why do you think so? Again, that might, okay, let's hear you.
Allow me straight up, I will say yes. And that's the current position of the law on this issue. But we will go back briefly to the old position and then cycle back. But the answer is a straight up yes. And yes, for the simple reason that, one, the employer has a right conferred by contract to terminate an employment as long as certain conditions are fulfilled. In this case, if the employee has acted in a manner that is deserving of disciplinary conduct, action, for instance, maybe he has misconducted himself, and that misconduct is also a crime, all right? Now, the employer has the powers to take disciplinary action against the employee. And don't forget, that disciplinary action will be an administrative sort of action. The employer does not have the right to investigate crimes, all right? And so we'll have to refer the criminal allegation element to the relevant authorities for possible investigation and prosecution. But in the meantime, if based on his disciplinary investigations, which is essentially administrative, it is found that the employee is guilty of that sort of misconduct that touches on crime, then the employer can terminate the employment. But of course, there's a precondition. And that precondition is that the employee must have been given fair hearing. He must have been given an opportunity to explain himself. The questions would have been put to him. He must have explained himself. I think that was part of the division of the NIC in Zenabo versus Bayero, BUK, Bayero University, where the court held that an employer has the power to discipline an employee for a misconduct, irrespective of whether any other action may be taken by public prosecutorial authorities. Let me go back a bit. Before this new position of the law, the position used to be that based on the presumption of innocence, that the employer will not be able to sack, right, until the prosecution process has been concluded before he cannot exercise the right to
Concluded,
But
yes.
I think, yes, but I think that there has been a shift from that position to the current position. Again, we saw that in the case of, I think in the case of Bangui versus the University of Ilorin, right? And the Court of Appeal decision is Okeme versus Civil Service Commission of Edo State, where the Court of Appeal held that in cases of misconduct bordering on criminality, all that is required of an employer before summarily dismissing the employee is to give him fair hearing by confronting him with the accusation made against him and requiring him to defend himself. So as long as that fair hearing is given, then of course the employer can take disciplinary action. But there's an interesting case I recall. I'm sure Arelabi will be aware of this case, Nigerian Bottling Corporation PLC and EPO, which is a recent decision, but where the old position of the law was retained. So it appears that can you hear me now?
Yes, we can hear you.
So NBC versus EPO, which sort of went back to the old position of the law, whereby it was held in NBC versus EPO that the employer could not have terminated the employment of the employee on conduct bordering on criminality until after criminal proceedings have been filed and determined. But I think the distinguishing factor in that case was that in the contract of employment itself, there was a clause to that effect. In the contract, in the employee's handbook, there was a clause to the effect that if such an event does occur, then the employee and the employer will have to await the outcome of the criminal investigation before he terminated. So I think it was that provision in the employee's handbook that the Court of Appeal, that the court, was enforcing when it made that pronouncement. So I think on the facts of NBC versus EPO, there's a difference from what the law is as of now, which is that generally an employer can terminate for criminal conduct which needs to be investigated. Afolabi, are you back?
Yes, I agree with you. Okay, please, do you agree or additional thoughts or disagree with the position?
It's an advantage to talk after Leonard Moka has appropriately analyzed the issues.
No, because
but I will just share an experience.
The ground.
I will share a personal experience about the matter I did. That is Olamido Oyewale against First Bank of Nigeria. And to emphasize what the learned just said, most practitioners do not advert their mind to this change in law. So you see, a lawyer waits for the outcome of the criminal proceedings in court. And when it does come before the National Industrial Court, the sole fulcrum of his case is that now that my client has been discharged and acquitted, I want NIC to pronounce that the termination was wrongful and unfair on the basis of that investigation. I've had about 3 cases in recent times. 2 of them were based on police report, because police, after their investigation, the claimant obtained a police report that says he did not commit any crime. On the basis of that, an action is now filed at NIC to ask NIC, since police have exonerated the claimant, pronounce that the termination by the employee was wrongful. But like NIC explained, they are completely 2 different matters. The right of the employer to discipline flows from the contract of employment. The prosecutorial authorities derive their right to prosecute as state, and the ingredients for both of them are also entirely different. To show that he has committed a misconduct is different from the requirements that would be needed to show that he has committed a crime. So in Oyewale's case that I mentioned, which was decided by Justice Essien just in 2021, the issue, the whole case of the claimant was changed on the fact that he has gone through a magistrate court had declared that he was innocent of the charges that were preferred against him. However, the court was able to find that the dismissal was properly done because he was given fair hearing, and the laid down procedure in the contract of employment was followed before he was dismissed. So the court upheld that decision. In fact, it was one of the rare cases where I see a claimant in the National Industrial Court, a defendant in the National Industrial Court proceeding on a counterclaim, because the court did not only dismiss his case, but awarded the counterclaim of the bank. Now, if I may say something a bit about the general question you asked about whether the NIC is balancing the rights of the employer and employee equally.
Yes, please go ahead.
Yes, I want to say that it is unfavorably tilted against the employer. And the reason is this. There are
the employer or the employee? Did you mean the employee or the employer?
I say it is against the employer.
Okay, against, okay, not in favor, correct.
No, not in favor,
okay.
It's against the employer. Because if you look at it critically, you will see that there are many positions which are uncertain until the National Industrial Court pronounces on them. If we listen to the position of the National Industrial Court, in fact, we listened to my lord, the president of the court, just a few days ago, you will see that there are some issues that, because there's not enough legislation in Nigeria, the National Industrial Court will want to go a certain way. All they needed was, I don't want to use the word goading, but it's for a proactive claimants counsel to look for ways to justify that relief. It could be in terms of international best practices, but you end up with a situation where maybe as a lawyer, you have given a legal opinion on an issue. And based on the facts of that peculiar case, the National Industrial Court, because of the way it is configured, because of its mandate, because of the application of international best practices, might end up giving a decision that ordinarily not supported by any precedent or any law before that time. So to that extent, I think there are some kind of advantage in favor of the claimant.
Afolabi, if I may just throw in my hat here before you
please
the ring before you ask the next question.
Yes.
You know, like I said initially, I wouldn't go as far as he has put it to say, oh, the decisions of the NIC are heavily unfavorable to the employers. Like I said, I would like to see an empirical study statistically to say, oh, these are the cases that have been decided in favor, and these are the cases that have been decided against employers. But I think the sound bites we get from the NIC and the general perception is that NIC is more pro or leans favorably towards employees. But like I said, I have also seen quite a good number of cases where the NIC have also decided against employees. A very good number of cases. So because ultimately it is the employees that approach the court more often than not, and it is them who have the burden, the responsibility of establishing their cases. And if they establish their cases, then they get judgment. All right. Absolutely. So the point I'm just trying to say is that I will be reluctant and I will say, let's not make a blanket statement that the NIC is generally in favor of employees against employers.
Leonard Silk, I completely share your thoughts. I equally enthuse the same sentiment at every opportunity. Maybe one has basically been opportune to follow a few of the decisions. And the president of the court, some days back, mentioned again, reiterated that. I think the perception generally, or the soundbite, as you would like to put it, is that it's strongly perceived as an employer's court. But again, I mean, because we're talking about empirical evidence, one. Two, this is case law analysis. I have before me at least about 12 cases that I just took time to just write out, that I thought reading through, the employee or the aggrieved employee in those cases should have an easy way to victory, because in some of the cases, the employer or the former employer, defendant employer, did not even file any process. In some of the cases, in a few others, the defendant employer filed a process, but did not defend, did not do anything beyond all of that, did not call evidence. And it's interesting we say this. Ige Adediro and Arik comes to mind. It's a case where the claimant sued against a summary dismissal and prayed for restatement. Arik did not even file a defense, did not as much as put in an appearance, but the courts, again, I won't say did the work for the employer, who didn't file anything. In analyzing the case to say that, I mean, declaratory reliefs, it is not the absence or the weakness of the defendant's case that will give you automatic victory. And we will not proceed on the general supposition or proposition of the law, the general blanket statement that, oh, if it's not defended, it is deemed as admitted. And the court still dismissed the case for lack of proof. You can imagine, the case was not defended. The court dismissed the case. James Oko and Lagos State University, Olubende and NURTW, in fact, about 13 listed there where you can easily just draw from. And I think just last week, there was another one that the president made that is against Aso Rock and Aso Savings. And again, it was defended in part, but in the course of the judgment, the defendant's pleadings or defendant's papers did not even make beyond the gates. So it wasn't even considered at all. But even at that, the former employee still did not make it. But that said, I agree that there are rough parts that, again, the court can still look into, especially along the line of damages, the award of compensable damages, and even the application of international-based labor practices, which will now lead me to the next question. International-based labor practices.
It might also pick your mind. Since you are talking about areas where they may appear to be imbalanced, the issue of looking into the reasons for termination. Ordinarily, the law is set that the National Industrial Court is not supposed to sit on appeal over the report of a disciplinary committee that has dismissed or terminated an employee. But if you see generally, there are decisions where the court will try to justify making an inquiry into the reasons behind the termination under whatever guise. So, and most of the time, there's a justification for it. Like in one of the recent decisions where the defendant failed to attach the report of the disciplinary panel at all, and the court held the absence of this report shows clearly that the proper thing was not done in the course of the proceedings. So if you look at it, I want to balance it with the expectations of an employer who believes he has followed all the laid down procedures, he has done everything he ought to do, and he was given fair hearing before the dismissal or termination. And then where the National Industrial Court starts to now inquire into the reasons for that termination. I know you're supposed to be asking me the questions.
Yes. Thank you. Well, I mean, when we are all supposed to have a bite at this, so I can as well take on the question. Again, I will be careful to draw the conclusion that the industrial court cannot look into the reports. For the simple reason that I don't think there's a case law that says that they cannot look
into look at the reasons or to review the report.
Yes, and I'll come to that. Yes, the reason I say that is ordinarily, even within the context of reliefs that we can go to court to seek, you can go to court, for example, to seek a relief that you want to review a decision of a body or just about anybody that in the course of coming to that conclusion or reaching that decision, you say is acted in some sort of judicial capacity. So that ordinarily connotes that the industrial court can well look into disciplinary court. But again, let me even take it from the particular example you gave. The particular example you gave, you said in one of the recent decisions, the court said that because the report was not brought forward, so it shows that.
Yeah, I agree with that decision anyway.
Because even without the industrial court, if you look at it from the point of view of evidence, within the evidence law, it is generally accepted that if you use the best evidence, you bring the best form of evidence forward to prove what happened, to show that this actually happened. And again, still within that same proposition, there is a fallback that, if you are supposed to bring forward a document and then you fail to, you are withholding evidence because it can be read that it will be against you. So I think the industrial court was on good ground, firm ground of law to come to a conclusion that if a report was not forwarded by a defendant company, we set up a committee, we set up the disciplinary panel, and they sat, and this is the report. And in the course of defending the case, the report could not be brought forward. The court would not assume that there was a report, and there's nothing that the court should look into. So the court would ordinarily come to that conclusion that you said the court came into. But let's go to international best practices, labor law, and all of that. It's been argued as an unruly force. It's been argued that it is not firmly backed up by any legislation apart from, okay, maybe the wording of 254 that of the Constitution, the third alteration that allows to look into that. But beyond all of that, it is usually subject to fact analysis that differ from one case to the other. And the bulk of what the industrial court is doing today falls within that particular prison, international based labor practices. So a number of cases submitted. So I would like to hear your thoughts. Do you think that the industrial court is on firm ground in applying international best practice to the world of work, taking into account maybe our local circumstances? And I remember that there was a question somebody asked at the panel discussion, at the session on Monday, but which was not answered. So maybe this is the way to import it. And it says, this is really stretching the ability of legislation. The Labor Act is so outdated, but it's being put side by side with the idea of international best practices. That is an interesting concept. Can we look at it close to say that really on firm ground, or is there something wrong that we think that the court should also still look into? And at some point, calling Mr. Osei-Okpeku to look at it from the perspective of discriminatory practices that the industrial court has actually been employing in different perspectives as well. So please, international based labor practices, what are your thoughts?
Okay, so let me go.
Yes.
The first question I'll ask myself: what is international best practice? What is that concept? Right? I think that is the beginning point. It means no more than the sort of practices and usages that we see that Committee of Nations and is acceptable widely in relation to work, right? So, but the common trend for international best practice should be that there must be an international acceptance, not what is predominantly practiced in any one particular jurisdiction in the world. So in other words, there must be a convergence of practices from various countries, from various nations, from various systems, and that is what represents international best practice, all right? Now, how come the NIC is applying international best practice? Of course, like you rightly mentioned, the third alteration, section 254, section 7 sub 6 of the NIC Act gives the NIC the latitude to apply international best practice. And this will international best practices and international labor conventions. Now, under international labor standards will come international labor conventions, right? By the ILO, like the international Convention 158 that the OK referred to, and other conventions. So where am I driving at? As long as the NIC is adopting into our labor law practice and jurisprudence international best practices and international labor standards that are widely and universally accepted, that is fair and good, because there is a convergence of opinion and practices in respect of those standards, and that's why they're international. So again, like I said before, the world is becoming a global village. standards must be, the standards in terms of work and all of that must be seen to be common, even though there will be variations in local legislations, but there are certain basic standards that are acceptable internationally, and these are what we call as international best practice. So I think the NIC is one, has legal basis for applying those standards. Two, I think it is applying them. But one worry I have is that the NIC has to be very careful to be able to ensure that whatever it is that it is applying in deciding any given case is actually international best standard or international best practice. I can't recall. I know I saw a decision where one judgment of the NIC where some practice in South Africa was cited as a basis for a particular decision. But what the judge, I don't want to mention his name, did not advance his mind to was that position in South Africa was based on a specific legislation in South Africa. So in that sense, will you say it's international best practice? No, it may be something that was appealing to the judge and he felt was that, but it was based on a specific legislation in South Africa. So I think in those areas we have to be a bit careful, but I agree generally that the NIC is doing very well in applying international best practices and international labor standards, and I will continue to encourage it to do so. But I think at every point in time, we need to understand what are those specific international best practices and standards that are being applied.
Yeah. I agree with you. I mean, though an employer will not agree with that, the International Court is applying international best practices. Ose, I don't know if you're there and you want to come in and tell us about seen from
it would be nice to hear the concept.
Yes, especially in discriminatory practices. There are quite a number of the decisions where they found are discriminating on account of gender, on account of sex, on account of religion, and it goes on sexual harassment and all of that.
Before I come in, you know, again, that will be based on Section 34 of the Constitution, right? And again, just what we call the Declaration of Human Rights universally, right? I'm trying to remember this convention on the Declaration of Human Rights, which is also an international best practice, because that's what Committee of Nations have come together. So I think applying those decisions against on discrimination. I can hear some interference.
Yes, I was going to say that it appears that's coming from Moses. Yes.
Also, can
coming from your head? Yes. Fantastic. Okay, I think it's better now. Yes. Okay.
So I was saying that the Supreme Court was, after the NIC, not Supreme Court, the NIC was is well within its rights to apply the provisions of Section 34 of the Constitution. Of course, we have the African Charter on Human and People's Rights as well, and then we have the Declaration on Human Rights, all of which tend to prevent discrimination of individuals. So, also, please, we'll be interested to get your perspective on this.
Interesting. Thank you. I hope everyone can hear me.
Yes.
Yes. Thank you.
Loud and clear. Yeah.
Good. Great stuff. Thank you, Daniel Silks, and okay. Thank you. You guys have I've enjoyed listening to the conversation and the brickbats back and forth, and it's been quite interesting. But before I even go on this, just to point out again, I mean, this was a conversation about references. In bringing this to practice in reality, if we are to advise your client, how would you advise your client? I mean, it's one thing, we've had this argument back and forth. I like to look at it from the practical point of view. And what I've always said to clients, and which has been very helpful, and I would like, maybe it work for you or not, is to say, whereas there's this issue around references, the safe path to take is actually, in giving references, to confirm date of employment and date of exit. Gordon Omwaka worked with the Lawcrest between the year 2000 and 2015 and left in 2015. And that's it. So you save yourself a lot of trouble. I mean, you're not giving an opinion as to the attitude of the person to work, but you're simply confirming based on your policy that this person worked between this period and to this period. And so what we've said to most clients, so make sure you have this in your policies. Oh, we don't have a reference policy, but we can confirm date of employment and date of exit. I mean, if you do that on the basis of that, you've actually walked very on the thin line. You've not given an opinion as to the person's attitude and work, but you've also somewhat satisfied the obligation, if there is one, to give a reference. I mean, I just thought to share that before.
Also, can I quickly say something to that? Fantastic way to perhaps give the employer some comfort. But the interesting thing is that I think, again, looking at it from the perspective or the viewpoint of the court as shared in Nwagwe and Fidelity, the employer may be compelled or is expected to give beyond such a terse information anytime that reference comes. So, I mean, you give what happens to be practical with just to avoid any possible issue, and then say you can confirm date of employment, date of disengagement. But in Nwagwe's case relied on an English authority that explained that our reference must also confirm the suitability of that candidate or that former employer and former employee for the role he kept in your office, he had when he was in your office. So if you, and so many reference forms, they come with specific questions, what they want you to comment on, as opposed to just a blanket reference. So how do you handle that in such a situation? I mean, looking at the practical way that you rather want to stay very careful.
Okay, again, if you think about it, every employment contract, there's an implied, the implied terms are actually implied in every employment contract. So there's the implied term of trust and confidence. There's implied term, in fact, giving good reference is an implied term of not damaging the employee's ability to get future work. Right? Statutorily, there is no express provision, right? Asking, I'm mandating the employer to give the reference. So your contract comes into play here. Your handbook and your other policies form part of your terms and conditions of employment. So typically, I mean, I could always distinguish the Nwagwe case, but typically, if you already have it in your handbook that as a company, as an organization, we do not give references to character and aptitude. What we do is to confirm this. Then you're only doing what you've contracted to do at that point. And so, I mean, we can have this argument for the rest of today, but again, these are all different scenarios, and depending, again, like I always say, rule of thumb is you need to look at the situation contextually, look at where you find yourself, and then look at the practical solution to it.
Also, it's remember that in this having, and I think I have some perspectives on that, but let's not go back on that.
Yes, let's go. Let's have your take. Let's have your take on within the wider perspective of discriminatory practices. You can please highlight specific ones, and then let's see if it fits into this application of international best labor practice. Because at every point, that's what the court has called it.
I mean, the watershed, like we all know for Nigeria, when it comes to discrimination, is sexual discrimination, right? And harassment. I mean, it's been the front burner issue for a while now, particularly for us in our own sector. And so I would like to dwell more on that aspect. But again, there are other discriminatory attitudes. I mean, for me, even with sexual harassment, the biggest issue is actually victimization and discrimination, not sexual harassment itself. So you report a case of sexual discrimination or harassment. And because of that, certain benefits are denied to you because you have reported this. That in itself is a different class of discrimination on its own. And it is very common, because the more you begin to see people report sexual harassment, the more you're beginning to see victimization and discrimination from that point of view. Now, the issue of, I mean, discrimination, again, the issue of remote working. So if I choose not to work remotely and I'm asked to resign on that basis because I cannot even afford to work remotely, have I been discriminated against? That's a different species of discrimination that we've not even touched on. But maybe I should just focus on the traditional discriminatory attitude. So you have gender discrimination. You have discrimination on the basis of your religious belief. But of them all, I mean, the one that has, to a very large extent, a concrete statutory framework is HIV. So the HIV Non-Discrimination Act clearly makes it an offense to refuse to employ someone or to deny someone of benefits because of their HIV status. That is one clear discriminatory statutory framework. But then if you look at other discriminatory attitudes or genres, then you have to seriously consider disability. So, and in that case, again, the only other state that has something close to that is Lagos State government, which has Lagos Special People's Act of Lagos State 2010 and 2015. And that clearly means that there has to be some criteria for any organization that attends to public, to members of the public, to creating an access way for people with wheelchairs, dedicating certain number of parking lots for people who have disability, and all that. So, and if you do not do this, then there is, how would I call it, there's the penalties for that. So in terms of statute, if you look at those two, those are core areas, but away from those traditional ones, I can't help but go back to sexual harassment, because that is the one that is typically covered by international best practice, if I go into that realm. So if you look at the 2017 National Industrial Court rules, that was the first time in Nigeria where there was a clear definition of what would amount to sexual harassment. Following on that, the Convention 190, 2019, sorry, Convention 190 on violence and harassment in the workplace clearly mirrors that same definition of sexual harassment in that convention. And again, if you look at Section 254C of the Constitution, which clearly allows National Industrial Court to apply international best practices as well as conventions which we have ratified, then that now forms part of our body of law. And National Industrial Court have used that quite a bit. And so if you also look at CEDAW, that's the ILO Convention on Elimination of Discrimination Against Women. If you put all that together, then you already have a body of law which is not just based on international best practice, but somewhat based on statute. I also need to make the point about international best practice, just to follow up on what Godwin said. I haven't agreed as the convergence of practices that people have generally come to accept. It's also a function of fact that has to be pleaded and proved. So it's one thing, again, to say, oh, this a convention that exists here and that. It has to be pleaded. It has to be proved, not just to plead it, but it has to be proved. And this is also the struggle. And my Lord Justice Kari keeps saying that it is somewhat worrying that lawyers in this space do not look at this before coming to court. And I've seen that in a lot of the judgments as well. And so, quite apart from it being international best practice, it has to be pleaded and proved. And so maybe I'll just drop this at this time and let's have that conversation continue.
Okay, thank you very much. I'll say thank you very much for the very rich and then illuminating thoughts on discrimination within the context or discriminatory practices found out by the NIC within the context of the power, judicial power to apply international based labor practices. Again, the question remains, and I see that you've addressed the one of sexual harassment, for example. And I would also like to take it from that perspective, throw it back in relation to the work of the NICN around that particular area. Now, discriminatory practice, sexual harassment, a decision on it came from the industrial court. First, in the case of trying to remember the other party now, but something to do with Council of Financial Reporting, where my Lord Honorable Justice Obaseki Osage came to the conclusion that that corporate entity or that establishment can also be held liable for the allegation of harassment leveled against the head of that establishment, who failed to give evidence. So what had happened was that the HR of the company had come to give evidence, but the court said, no, in this sort of a case, the allegation was specifically against an individual. It should be the one to come and give the evidence. So this is another deviation from what I was saying earlier on as to the evolving jurisprudence and the work of the courts in bringing the various international based labor practices and how it should be interpreted or determined. Ordinarily, a company is expected to have just about anybody that can testify go to court and speak on his behalf, because the company speaks through human persons. But in that decision, I recall that specifically the case went that way because the particular individual that was alleged to have sexually harassed or was sexually harassing the claimant had asked, since the company was also sued, the HR personnel to be the one to give evidence. And I relate that to the practice that is that not setting a new benchmark that once there's an allegation of discriminatory practice, it has to be the individual, even though it's a company, that must give evidence.
Afolabi, let me come in here, right?
Yes.
I think at the time that decision that you referred to was handed down,
yes,
while a lot of us applauded it, because I think at that time it was
the very first one, yes.
Yeah, grand division. We were also alarmed at the precise point you made, because if the allegation of sexual harassment is an allegation of infraction by a particular individual, first and foremost, don't forget that in a company, as we all know, is a separate legal personality, right? That's too basic enough. But in carrying out, in sexually harassing somebody, the actor would actually not be acting on the instruction of the company. He would actually be working beyond the scope of his employment, because these are not things that organizations would generally actively promote or encourage. So to hold the company personally liable for that sort of sexual harassment, which is basically, it was an individual act. Well, to say the least, in my view, I thought at the time was too drastic a measure, right? If there had been a company policy, if there had been a company culture of active support and encouragement of sexual harassment, then perhaps. But to say that because the individual who was involved perhaps was nowhere found to come at the time to give evidence, and so it was then the remit of the company to defend the allegation or to give evidence in rebuttal, I really struggle to accept that and to live with that. I struggle. So for me, I think that is where that particular decision that you referred to got it wrong in a manner of speaking. But otherwise, I think it is for the individual who has committed the act of sexual harassment to be responsible for his conduct, except you can show, as I've said, that the company, the company was aware of it and actively supported or encouraged. Then, of course, you can now ascribe some sort of liability to the company on that ground, on the basis of some sort of collaborative or collusive or institutional failure or systemic failure, but not to hold the company liable for the act of the individual. Thank you.
Which was the decision? Yeah, I agree with you. Which was the decision that came up subsequently in Maduka and Microsoft, because it was Microsoft was found liable for failing to investigate that sexual harassment claim. So they were both liable on that score. Okay, let me come to you, and and please stay on. I would also want your take on this.
Okay, if I may say something on this.
This has to do. Oh, okay. Please go ahead.
Okay, yeah. You know, you spoke earlier about the best evidence rule.
Yeah.
So I also think that might be the thinking of the NIC, because the best evidence to report the sexual harassment would have been of the person who was involved, who was alleged to have done those things. Yeah. Now, I don't think there should be a general policy that says we are that person first to come. It should be appraised on the evidential value that his absence will bring. Because if the person who testified actually testified on behalf of the company, testified from the records of the company, he's a fit witness to testify. But if the court, for some reason, do not believe his evidence, I believe if that distinction was made on that basis, would have been more acceptable.
Fantastic. Fantastic. I totally share your thoughts there. Let's move. Let's take it further to right of privacy. Somebody has asked that we're talking about giving reference letters. That wouldn't that be violating the employees or former employees' right to privacy? But hold the thoughts before you answer that, and then this would also go round. Let me add additional questions, related questions to that. Can an employer run background checks on potential employees before hire? And then are there limitations on the scope of check? How do employee data protection rights affect the employment relationship? And I don't know whether I should ask this now, but it's also related, even though I think it's on a class of its own. Can an employer control the employee's use of social media in and out of the workplace? Can my employer say that or regulate the sort of information I put out there on my Facebook page or the WhatsApp group that I belong to or what I share on social media? Again, within the new evolving world of work, do you think the employer has the rights?
Well, please, let me take the first question.
Okay, please go ahead.
Asked, then I'll defer to for the rest.
Yeah, okay, please. And then, yes, I agree with you. Please take the one you're comfortable, and then we'll pass it around. Let us say we are dealing with social media, running background checks and all that and related. Yes. Is there any way or any? Oh, please go ahead.
Okay, the participant was asking whether giving reference will not infringe on the employee's right to privacy.
Yes.
I don't see how this will arise, because actually the reference is requested for, it is for the benefit of the employee. That's why we are talking about whether there should be an implied time that the employer must give it. When a reference is requested, it is to benefit the employee who is moving on to another job. We've explained that point clearly before, that it is where, for any reason, the employer has given inaccurate, unfair information in the reference, that he exposes himself to any kind of liability. On background check, my quick thought is that it is something that is done every day. And I believe I've not come across any decision of NIC. I don't know whether it has been dealt with, but generally I know employers do this. And then there are possible dangers that employers could be exposed to. because if you could be infringing on the right to privacy, which is guaranteed under the Constitution, and also our data protection laws are very robust on the kind of information you can get without somebody's consent. So the best approach would be to, even if it is a prospective employer, to obtain his consent to run those checks. And then depending on the information that is disclosed to you, how you use that information might also expose the employer to liability.
Thank you very much. Ose.
Great.
Let us say.
Thank you, Folabi, and thank you, okay. I think you got it spot on. But before I go into that, I just need to clarify some question I saw on there. And I'd mentioned in my earlier talk about remote working and you're not being able to work remotely, losing your job, being discriminatory. And someone said, had had a question how can that be discriminatory? I mean, you need to look at it from the point of view that discrimination is being treated differently from another person based on society criteria. So if for some reason where I live, I don't have access to light or there's no internet access and all that, and I cannot work at home, you then say to me, oh, you must all work from home and work 24 hours because it's presumed that you have light and data. If a certain number of us do not have access to that and we then lose our job, then that treatment, that standard has been set, has become a discriminatory standard for us. And so that's where I was looking at it from. Not that remote working itself is discriminatory, but it's a standard that you set towards achieving the remote working that could be discriminatory. And so just to move forward to what OK dealt with now. Yes, okay, I absolutely agree with you. So it's in most crimes, if there's the need to do a background check, you'll be informed ahead when you apply for a particular job that background check will be carried out and you give your consent for that to happen. But again, also, even in the financial service sector in Nigeria, I mean, the banks and financial institutions have an obligation to actually document employees who have been dismissed for fraud with the CBN. And so there's a certain level of CRB check that you also need to carry out. And so there's that as well. So, I mean, the rule of thumb is really, if it is a case that you need to carry out a check that might somewhat affect the ability of that individual to get that job, then the proper thing to do and the real thing to do, the practical thing to do is to obtain consent before carrying out the background check. Philip, what was the other part of the question again?
Okay, yes, I'm still around that. Is that okay?
Social media.
Let's take social media. And social media, I'm looking to both the Silk and then yourself to touch on social media. And I don't know if I can give an additional context to that.
Go on.
I mean, there's this background context that I often bring forward. I recall that sometime, I think it was about 2 years ago, the chairman of the editorial board of a leading Nigerian newspaper on his Facebook page,
Vanguard,
was having a banter with his friend. He was having a banter with his friend, and in the course of it, I think the friend put forward this stride that, well, you know, I'm a Yoruba man, we're well educated, we're whatever, and all of that. And in response, like I said, a banter, I mean, light conversation between two friends. This editor wrote, yes,
Have we lost Afolabi?
I think so.
I think so.
Looks like.
Hello?
Okay.
Hello, can you hear me?
Yes, I hear you now.
We've lost him.
Let us say, Komaka, maybe you can begin to give us your insight right before you come back.
Well, my insight is that there is no specific legislation, right, regulating the use of social media in the workplace and beyond. You won't find any. And so it is left to individual organizations, there is individual companies to put in place internal regulations for the use of their employees. So an employee may prescribe rules around the use of social media in the workplace. I may implement
yes. Sorry. Oh,
that
okay,
prevent.
I'm back.
Okay.
Okay.
I was just already having a bite at the cherry of social
Well,
media.
let me hold the thought. Let me just give this background factor and context, and then you could take it further from there. So that individual said that, and somehow within 2 or 3 days, it affected the sales of this particular newspaper, Vanguard newspaper, to be precise, because people took it out of context. That
I think we didn't get the response of the person. The second person, that was
the
very
response.
soft. Yes.
Okay, so yes, so he had said that the friend had said, yes, I'm from this part of town, and then we're educated, sophisticated, and all that. Then his friend, who happens to be the chairman of the editorial board of Vanguard newspaper, said, yes, I know you people are like that, but Yorubas, you're sophisticated idiots, or something that seemed to have a tribal law. But again, it was just a light conversation between two parties. But somehow, the power of the social media, it got beamed out there, and it was taken to be and extended to be that, this is the viewpoint of Vanguard newspaper. And within 2 days or a week, the sales of Vanguard newspaper went down. There was a dip in sales. It really affected because I think those from the tribe affected decided to have a boycott, that we're not going to buy Vanguard newspaper now. This newspaper had to now come out with a release. It was a public release that, and if it's anything like this, we take it that, and let me say this, we disassociate ourselves from that statement. That statement is just a conversation as between them, and in any event, doesn't represent the viewpoint of Vanguard newspaper about any tribe at all in Nigeria. So that's basically rescued the sales, but of course not without it having an impact on the reputation or even the financials of the company at that particular period. I mean, that newspaper house. And I thought about it that it shouldn't. So, I mean, what was the takeaway that I took away from that when it happened, when I needed to address a handbook that didn't have a social media policy, was that could that have been a basis? Of course, it didn't happen that way. But could Vanguard have used that to terminate the employment of that individual? Could he have been thrown under the bus just because they needed to make a statement that indeed we do not support this, even though it was a light banter and it's taking a deeper bet, and to show that we do not support this, you have been fired. So it goes back to social media policy. Do you have to have a social media policy in the handbook that says, for example, you are not to represent that you work with XYZ on any of your social media handles, or just in any other form or shape? Can the employer control the use of social media, the employee's social media, in and out of workplace? For example, can you say that in the course of work between 9 and 5, you should not be seen to have any conversation on WhatsApp or on Facebook? So please proceed.
So, Afolabi, the incident you referred to, I think, was something we all are aware of, and it was an unfortunate turn of events. But like you said,
Yes.
It was light-hearted banter, and people, unfortunately and sadly, read into that innocuous comment between two friends, what was not supposed to be there. All right. And like you rightly noted, it led to a plummeting in the sales of that particular newspaper. But coming to the specific question, which is, can an employer control the use of social media? I think the first point from my perspective is that first and foremost, there is no legislation in this country on that. Secondly, I believe the employer can. It is up to the employer to put in place internally, perhaps in a handbook or some sort of circular that may be incorporated into the terms of employment or conditions of employment, regulations on the use of social media. In other words, maybe when you are at the place of work, you should not be seen to be engaged in social media practices that will be detrimental to the promotion of our business, to my work, all right? then you will have to clearly identify what those what those activities are, and then define their boundaries. But of course, you cannot restrict the right of the individual to interact generally on social media. You cannot, especially what he or she is saying, and that is the example of the Vanguard case that we saw, actually has no correlation with your work. That again would be interfering with the party, with the employer's right of freedom of expression on whatever platform you have it. So, but I think that you can use it to restrict. You can impose it. You can impose restrictions on the publication of official company information, so that your employees do not disclose official company information to members of the public. But beyond these very limited instances, I don't really think that an employer can regulate how or circumscribe how an employee uses social media. Don't forget the use of social media has a constitutional backing as well, which is the right to freedom of expression, and again, there's access to information by people and all of that. So there are public policy considerations that we will need to take into consideration as well, and balance it. But I think when it comes to the question where its use may be detrimental or may have a deleterious effect on the business of the employer, then there may just be scope for that sort of regulation.
Oh, thank you very much. You want to have a bite? Yes.
Yes. I mean, again, we need to put this in context as well. I would say it would depend on who is involved here. And so there are some very sensitive positions that people hold in organizations. And so people in those positions, when they make statements or comments, could be seen as the position of the organization. So in practical terms, for most such organizations, for such positions, organizations will usually have what they will call a social media, social media, I'm trying to get the name now, a social media guiding policy. So the idea is, because you're in such a sensitive position, so let's say the brand manager or the public communications manager or someone or the MD or someone, because they understand the sensitivity of your position and the fact that your view could easily be translated to be the view of the organization, which could be detrimental to it in the long run, then there's a certain level of restriction to your use of social media and the views you express on social media. So most times, if you want to express a personal view of social media, a check is run on it before you're allowed to release it. So that at every time you're ticking all the boxes, that it does not come back to bite the organization. That's on specific rules. But generally, I mean, Gordon Omaka makes the point that there's the issue of freedom of expression there, which is a constitutionally enshrined right. But again, we also know that those rights are not inelastic. I mean, they're not absolute. So there has to be some certain level of restrictions to that. But again, the other aspect of it, I just needed to throw the cat among the pigeons, is the fact that we see more often now, even in other climes, employers trolling the social media handles of prospective employees. I mean, it's something that helps to actually help them have an idea of who this person is, if this person actually makes a perfect fit. So apart from the legal aspect, employees have to also be careful, because the views you express on social media could come back to haunt you when you're looking for a job, because prospective employers are looking at your comments on Facebook, your comments on Twitter, and if you then in a situation where you are exposing what we call hate speech or ethno-tribalistic speech, and then you have that on your timeline, then it is a disadvantage for you, because in times when it comes to recruitment, a lot of employers are doing it. So you cannot stop a prospective employer from trolling social media handles to say, oh, okay, what's happening here? What's it? And again, in real sense now, when you apply for roles, and I see this over and over again, the employers will ask you to please state your Twitter handle, your LinkedIn page. And I mean, is there a legal basis for that? Maybe I'll throw this back to you, Falabi. Is there a legal basis for
we actually, you see, what I want to say to that is that such an employer is probably not aware of the letters of the law relating, drawing from data protection regulations, because it's quite expansive. You even need the consent of the employee or the individual you are requiring such information, such an information from, before you can even proceed to say you want to own it or you want to use it for anything and all of that. So yes, it can throw such an employer open for possible liability if an action is made out by the employee. Okay, and still on this, there is also a related question, which I don't know how related it is, but I think somewhere along the line, ticking the boxes, we can still be able to conveniently talk this in. Restrictions. Are there any restrictions or prohibitions against requiring the medical examination as a condition for employment? Are there restrictions or prohibitions, or the employer is obliged to require medical examination to be carried out? As we often see, the employee or the prospective employee has passed a particular stage of the interview session, and then is now being asked to go run some medical checks. They're quite a long, the list is quite long on the number of tests that such prospective employees are usually asked to undergo. And depending on the result, the employer can decide to proceed, and at the same time decide not to proceed with the employment. So the question is, are there restrictions or prohibitions against such?
I mean, generally, if you look at, I'm trying to remember off the top of my head, the Section of the Labor Act that allows employers to carry out pre-employment medical checks to be sure that the employee is fit for the medically fit for the role. Yes, there are restrictions. And I believe I've mentioned earlier the issue of the HIV Non-Discrimination Act. So clearly, even if you carry out a medical check to see if someone is someone's HIV status, you cannot refuse to offer them employment because of their HIV status. So even if you are able to, you carry out, and so really, you shouldn't even carry out practice for the HIV status. So in terms of medical check, it's actually to see their fitness for the role as prescribed by law, yes. But you cannot discriminate against them on the basis of their medical condition. So that's that for me. I mean, in a nutshell, that's the restriction. And
okay, let's look at the practical situation. Yeah.
Okay. So,
please go on.
So for argument's sake, we're in the COVID era.
Yes.
So if someone comes in and tests, well, is it positive or negative? Now, nobody seems to be sure positive for COVID. Would you say, because you cannot discriminate, you would then keep the person walking, or you ask the person to go and get themselves treated and come back before they get an employment?
Do you want me to take on that?
So Ose,
you want me to bring that back at you?
Okay, fantastic, Ose. Yes. And let us before I allow you to come in. And I think I had a similar scenario. I was going to paint a similar scenario because it doesn't appear as if that is even alleged. It's not a blanket restriction, if there is any. My knowledge about even the one about HIV/AIDS, and which has come up before the industrial court in our 2 cases now, is that consent must be obtained.
Yeah,
it's not that an employer cannot ask an employee to go carry out an HIV test. what it says is that it must be a consensual arrangement. That is, the employee agrees that I will carry out, I will undergo this test. That's one. Two, depending on the result, can it be a basis of terminating or refusing to employ? Well, I'll answer this way. For HIV, it cannot be a basis. For an opportunistic infection like COVID, an opportunistic infection that can just be picked in the air or by contact with fellow human beings and all that, just contact, it can be a basis. The reason is that, again, within the context of overriding public policy consideration, utilitarian value, utilitarian perspective in law, that employer also has a duty, to ensure that the co-employees at work, they are protected. And then when you look at the discourse or the discussion around safety, health and safety in workplace, you will know that indeed the employer can validly make a case, but this is the reason why you will be asked to stay off, maybe from this, or this is the reason why we cannot engage you. That would be my point. I don't know if
that's absolutely. I agree with
that's
you.
Absolutely, and I agree with you. And going back to the COVID point, we saw jurisprudence coming out from the United States recently at the heart of COVID, where some employees went to court to challenge certain safety policies that were put in place by their employers on the ground that they were thought of discriminatory against them or so. And the court held that no, overriding public health considerations will require that you comply with those policies. So I think that is the baseline jurisprudential basis for saying that discrimination cannot, that such an act will not be discriminatory. But like Folabi said, and like Ofe also rightly pointed out, you cannot use that, for instance, the HIV case, you cannot use it as a basis for either a sack or a dismissal of the employee. And I think one case that readily comes to mind is the Onukwemi case, where the respondent's dismissal on the ground that he was HIV positive was found by the court to be a violation of his fundamental human rights to dignity and freedom. So the point being that employers must always be very careful to know where to set the boundaries and the lines, because otherwise they could fundamentally potentially be liable for infringement of the rights of employees if they discriminate against them on the ground of their medical status.
Now, extending an industrial code always lean on international best labor practices. So I would imagine that if these were to come forward, would come up in the future, and depending on the fact analysis being brought forward in that particular case, the court would perhaps have to look abroad. I'm aware that in India, a decision has been made now that even with HIV, relatively to the sector, it is a food industry, it can be a reason to discriminate. So the answer is not, it wouldn't apply across board.
Yes.
It will not apply across board.
Like you said,
there's a decision that
the
food industry, and I think they extended it to hospitals, yes. In certain job-specific and all of that, it's been argued and it's been upheld that it will not be, and that can be a reason for not engaging such a person, and it will not be held to discrimination.
Apology, I'm just seeing a question, say a person employing a nanny may be entitled to terminate for reason of HIV. Yes, because like, and that was the point I was going to make, that it will be fact specific, right? Because if it is an industry where the exposure will be high and there's a risk of transmission as a result of the work, then of course you have to protect the wider health, public health. And on that basis, I think a solid case can be made for an exclusion on the basis of a potential wider public health implication.
Yes.
And the same policy would apply to a private employer who is trying to employ a nanny, for instance, in his or her house. I mean, a nanny is there to be employed to take care of children. And if you can demonstrate that the nanny would potentially infect those children as a result of his or her status, then perhaps, again, a case could be made for non-employment or termination on that basis. So, you know, it's a bit tricky, but there are fact-specific inquiries to be made. But I would also say that I cannot rule out completely the possibility of non-employment, which may not be regarded as discriminatory because of the fact-sensitive nature and the wider public health interest issues that may likely arise.
Okay, fantastic. Thank you very much. And going inbox, there's a question there. Is it right for an employer, maybe based on his policy, to make it mandatory that his employees patronize his products and must not choose another over those of the employer? So that is a question somebody has asked. I think it's from Nosakere Demo there. Okay, sorry, from Simon Beshma. That is it right?
I think it will be clearly discriminatory because the decision of NIC was just a question of
access
the employer. Yeah. Hello, can you hear me?
Please go ahead. Please go ahead. Okay, I can hear you.
Yes. So NIC have decided that an employer who asks his workers, his employees, to bank with a specific bank.
On Access Bank.
Yes, that it was discriminatory. So I would think that asking people to patronize certain products belonging to you will equally be discriminatory. There's no doubt about it.
Indeed, you're absolutely right. And that's what I had in mind about that. But for one moment, let's look at it from the perspective of the employer. What is wrong in promoting the business of the employer?
I think that would be
you have to give choices. You have to be a choice.
Yeah. So it will be against the spirit of.
Maybe it depends on the kind of product we're talking about. If it's, take for example, a car manufacturer who wants his employees to drive his car, I think he might find a justification for it. But say, for example, that I sell food, and I say, if you work for me, you must eat only my food. I don't think why the other person might just fight in terms of branding. I don't think the latter person can just fight in terms of branding, because I don't see how you want to market Bojo for me, and meanwhile you are driving Toyota. So maybe depending the way NIC have always handled issues, they want to look at facts of this particular case before they arrive at the decision. So I think the facts will also have to play a role.
But okay, the point my response to that will be that yes, there could be a case to be made for the first scenario you gave because of the branding issue. But then as an employer and a business, if I want my employees to market my product out there, then I should give them an incentive to do so, and not to make it obligatory on them to buy the product, all right? Because people also have a choice in terms of cars, as indeed in terms of every other commodity. So in terms of branding, I rather see it more as incentivizing them to say, oh, okay, I'm giving you a car maybe at a heavily discounted way or even free, so that it comes that appetite for another choice. And then all my employees will be seen to be driving that particular brand of car. Otherwise, I fear and I worry that you could potentially be straying into the realm of infringement of their rights and potential discriminatory practice, if you are to compel them to move towards your own product.
I agree.
Okay, fantastic. So let's bring it home in recent happenings, COVID-19. Two questions around that area. COVID-19 happened in 2019, and then we all, is it 2020, we woke up to a sudden realization that, oh, maybe work in a physical setting before now was vastly exaggerated. A lot of things get done. You could work from home, and technology has enabled the use of the computer to get around a number of things, but invariably it comes with new terms and conditions of work that before now were not thought of. What would be your take in relation to the 9 to 5 prescription of work? In the light of COVID and work from home, I know fully well that working from home, most times, even at midnight, in some workplaces, you are still dealing with some email, dealing with a client issue and all. Is it necessary? Do you think that it's necessary to now revise and change the terms of conditions of work to accommodate or reflect the new phase of work, that is work from home model, in the light of COVID-19 imposed realities? And if yes, to what extent do you think that may ultimately be altering the condition of service that parties entered into when the contract of employment was originally entered into? And okay, I'll take that. Then I'll come to accidents, or what can be said to be an accident in the workplace, now extending home. But let's start with COVID-19, the new reality of work. What do you think an employer really should be doing, and what do you think are the rights of the employee? I mean, the employee in this new phased work, please.
Folabi, interesting. Yes. I mean, the frontiers of the employment relationship and the boundaries keep being moved forward and being shifted. I mean, if you think about it, prior to Hurricane Katrina, force majeure was an unknown factor in employment relationships. So, but after Hurricane Katrina, the United States were one of the first few, jurisdictions that started inserting force majeure into employment contracts. Because it then so happened that because of circumstances, they couldn't do anything about the employees. And they were stuck with having to pay salaries and all that. And, we don't have a litigious nature, but in America, everybody sues. So while they were still at 8, people were already going to other states to go and sue organizations in Louisiana that they cannot actually terminate their contract because force majeure was unknown to their employment contract. And so the point I try to make is that the employment relationship will keep evolving. I mean, if you think about it, by the year 2040, majority of the workforce will be populated by those born between 2000, actually. And these are the millennials. And this set of people are opinionated, they know what they want, and they work with their feet. And part of what they actually enjoy and want to see is different work models, different from the 9 to 5 typical traditional work models they have. So they are looking at atypical work models of the typical work models. And so what COVID has done was to help push it, making the front burner in countries like ours. But in different countries, other countries, 2 days in the office, 1 day out of the office, working from shared spaces have become a norm. And so perhaps it is time for us to start getting used to the idea that the typical 9 to 5 job, perhaps in the private sector, but this might not work in the public sector, perhaps in the private sector, the typical 9 to 5 work pattern that we're used to can no longer be the norm. I mean, if you intend to attract the best and to keep the best, one of the driving factors for retention right now, if you ask any consulting company, it's the ability to offer different work patterns, which somewhat fits into the lifestyle of this brand. So we've moved from work-life balance to what is now called work-life integration. So we're looking at how to integrate various aspects of their life, their social life, their work life, and the various patterns that work so that they can actually deliver at their optimum. So in essence, whether we like it or not, we might fight against it, we might push back, we might have pushback. Reality is that the typical 9 to 5 work pattern will not be the norm going forward. I mean, if you think about it, the situation, even in Nigeria right now, a lot of banks I hear are closing by 4 or 3 o'clock because the cost of running the organization with diesel means that it might even be better for them to ask the employees to work from home, and then they save on those costs. So, I mean, the bottom line is we must understand, we have to understand that going forward, the typical 9 to 5 work pattern will not be a functional model that suits everyone. There has to be different work models that would appeal to different people.
So what are the corresponding obligations on the new employer in this new model? You mentioned diesel the other time. So it works from home, and you know how much diesel sells now. It needs to get that so power is,
I mean,
to power his system to be able to work. Yes.
I've raised that issue. Therein lies the conundrum. I mean,
yes,
we would have to deal with each situation contextually as you find yourself in it. I do know that some organizations, which we did work on some in during the COVID period, had to set up solar panels for strategic employees at home who could afford not to be working. And so additional data, solar panels and all that, just to create a work environment for them to be able to work. I mean, I know you did mention that you are going to go into that. Does it then mean that the work environment has now been extended to
the remote
workplace?
Yes.
With the obligations of an employer to create a safe work environment, which is both statutory, common law, and implied, would it then extend to the remote workplace? And these are issues that we'll have to address on each individual contextual case.
I can go on and on, but I just look at the time and it's 3:08. So I'll just leave the last question to the CELC and then to deal with, which is still coming from this. It is accidents in the workplace. Okay. Now, the Employment Compensation Act was made in 2010, and then the provision there is quite expansive as to what would constitute an accident. And it didn't look at the workplace as being a traditional physical structure. It says accident is an occurrence arising out of or in the course of work. Occurrence arising out of or in the course of work. So work being conducted at home can invariably lead to what a claim can be made for as an accident within the scope of the Employment Compensation Act. Now, the question is this: in the light of this new phased world of work or hybrid work from work setting, which COVID has imposed on us, do you agree that this 2010 legislation is broad enough to include accidents that occur between the employer's physical workplace and the employee's principal or physical residence, and occupational accidents at the employee's physical residence? So do you think this legislation can actually be used to make a case for injuries arising from the conduct of work, even though it's in the employee's private room? Is it one that can be made? Hello?
So you want me to go, sir?
Yes, please. Yes, please.
Oh, yeah. So like Osel rightly noted, right? We have seen a gradual extension of the work environment into people's home as a result of disruptions caused by the pandemic and development in technology. Yes. People are now using the word disruptive technology. I am of the view that in the next maybe perhaps 20, 30 years, the workplace as we know it, especially for some professions, will disappear. You may not need to have physical offices anymore. But I mean, that's a separate conversation to be had for another day, right? And especially for our profession, the legal profession. It may just turn out that everybody is really working from wherever they are. I don't need those physical offices. But coming to the question at hand, if you look at the definition that the Employers' Compensation Act provides for an accident, it talks about an occurrence in the course of work. So that definition is not limited to happenings that occur at a physical place, but as a particular physical place. So to the extent and insofar as you are carrying the work of your employer, whether in your house, whether in the car, whether in the office, and there's an accident that results from that, I think it's an accident that will be covered by the provisions of the Employment Compensation Act, even though the definition as we know it today is not there. But because of that phrase, in the course of employment, I think it is expansive enough to cover any situations that arise in the course of employment, regardless of where that occurrence takes place. So, for instance, if I am doing some job for my employer, not in my offices, but at some location, and in the process, I get injured, I believe that my employer should be able to compensate me for that, regardless of whether or not, regardless of the fact that the accident did not happen in my office. So I think it will cover those instances where someone is working in his house, he's at home, he's working in his house, but again, there's going to be a fact inquiry here, right? At the time of the incident, what was he doing? Was he, even if he's in his house, was he working? Was it in the course of his employment? Because I think that is the critical and determining factor. So if it is shown that he was in his house and it was in the course of his employment, then I think such broad interpretation of the act will suffice. But
thank you very much.
Inquiry will have to be made.
Well, thank you very much. Okay, I don't know if you have any additional thoughts.
Okay,
or this
just to add something quickly. Why I agree with the analysis sake that the definition provided by the ECA is broad enough, saying the course of work or arising out of work. However, what I'm looking at is there's also the obligation on an employer to provide a safe work environment. Are you going to extend that to the man's house? Assuming he's working and left water on the ground and he sleep on it, because it was in the course of work. So I believe there should be a need for some kind of legislation, or companies should come up with remote work policies.
That will compel the employer to ensure that the house of the employee is properly tiled to soak in that water so that we don't
no. Okay. It depends on who you are taking for. It depends on who you are taking for. Let me come. If you are taking for the employee, if you are properly tiled, if you are taking for the employee, if you will absorb. Let me make this point. Yeah. If you are taking for the employee, you'll be expecting that the employer will now come to make his house safe for work. But if you are taking for the employer, as I'm thinking now, you have to limit those liabilities, because the employee who lives in that house should be able to provide safety in his own house. So in the course of work, arising out of work have to be defined as to what is the nature of the injury that occur to that person. If an employer allows his employees to take home work, as many you work with chemicals, and you allow an employee to take it home, and while he's working with them, he got injured by the chemicals. It's a different scenario that a man who is working in his home has failed to put in proper electrical fittings and got electrocuted in the process, and you want to now transfer the responsibility to the employer. So I think this scenario will have to be looked at critically.
So, okay, quick response to that, right?
Okay.
Like I said, a fact-specific inquiry will have to be made. But personally, I'm not a great fan of legislative intervention in every scenario, in every situation. Otherwise, we're going to legislate ourselves out of existence. I think that there's a role for the development of our jurisprudence here by our courts, and this is where the interpretative functions of the courts will come in. Clearly, I would expect the courts, when the issue comes, to set us to delimit the scope and set the boundaries for us as to, and give clear guidance, because by the time you begin to do legislation, you can't write every A, B, C, and D of every conceivable situation into a statute book.
Yes.
All right. So
Yeah.
that's just the point I really wanted to make. Thank you.
And interestingly, on this point,
I was just going to say
Yes.
the point that even I mean, no need to belabor the point, but even if you look at the definition of workplace under the ECA, it has to describe it as a place of work that has been agreed between the employer and the employee as to where he will carry out his job. So that, I mean, stretches the boundaries of where the work can take place in and also. And again, I do know employers who, during the COVID time, had to carry out safety audits. And so if you actually have a remote working policy, it will clearly state that in part of your house, you set up this particular space that is very safe and blah, 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 for you to carry out your work. So most employers will go out and carry out a safety audit. But how practical is that if you have over 1,000 employees? How many employees are you going to carry out safety audits for? I mean, those are all up in the air and things to discuss. Thank you.
Even if I'm allowed to just bring it within the context of how the industrial court has looked at it, not exactly similar scenario, but a scenario of what is the level, or what is the expectation, the level of expectation that is expected on the part of the employer in providing
a safe work environment,
a safe workplace, and or to anticipate and provide ahead what can possibly come from an employee carrying out or discharging his duties. 2 years ago, there was a decision from the industrial court related to an individual, a bank manager whose work involved moving from, I think it was a regional manager. So it was involved with moving from a state to another state at every point in time to perhaps just oversee the branches within that particular region. And in the course of that, on a particular day, he had an accident and ran into, not just an accident, ran into an armed robbery attack, and caused an accident, suffered a spinal cord injury, and was hospitalized, taken care of for quite some time. And something led to the other. I wouldn't exactly say it was a termination, but he had to bring an action against the company, against this bank. And the action specifically was asking that, but for the fact that he had an accident, he would not have had a spinal cord injury. That's one. Two, if the bank had provided him police protection, that would not have happened. And the industrial court looked at it and came to the conclusion that police protection perhaps would have been required if the course of his work included moving from one region or one state to the other with bullion van. But if it was just moving from one place to the other without necessarily having to move around with money and all of that, except Nigeria is over police already, it will be overstretching it to expect the employer to provide police protection at that point in time. And that what had happened could have happened anyway. And without that police, I mean, that expectation of police providing police protection, and was on that basis that the court did not agree with the argument that he was not fairly treated or well protected in the discharge of his duty. As I speak, I'm trying to lay hold on the particular case because I see a few persons asking, okay, this is Bite Adegoke and Ecobank. Bite Adegoke and Ecobank, where a bank manager on a road trip to Lagos on official assignment was attacked by armed robbers and sustained a spinal cord injury from a gunshot. The court held entirely that the bank did not owe him a duty to provide police protection on that trip, similar to what would normally have been provided if he was moving huge sums of cash, money from one branch to the other. When I read the decision, well, at least to an extent, he absolved the employer from what I would call an overinflated expectation of the level of security or safety provisions that will be expected at the workplace for the employee. But beyond all of that, it got me questioning some rationale in the decision. And then the question relates to the fact that he had an accident. It was moving with money. It would have been provided for with security. So the question is, what exactly does the court protect? Is it money or human life? But I'll leave it that way. So, I mean, there's a balancing act that at the end of the day, the industrial court, based on what comes up before the court, would take into cognizance of before ascribing liability, if any, on the employer for failing to see to the particular provision or expectation of what is the work and safety requirement that the employee was making or is making before the court, and so on and so on. I think that would be that would be it. We were to have this between 1 and 2, later 1 and 3. I see that it's already it's about 22 minutes beyond 3 o'clock now. It's a convenient place to bring it to an end, even though one would have loved a situation where we could take all the questions, but it's just possible. At this point, I again will thank all the panelists. We thank you for staying tuned and then being able to come up with very illuminating, incisive, and enriching answers to the questions posed. It's been educative. I do not want to go into the box to be reading all the beautiful adjectives that have been used to describe your responses. And I also, at this, will take time to thank the Institute of Continuing Legal Education of the NBA under the able leadership of Mr. Tobin Erojikwe, who I will now hand over to for organizing this, putting this together. And also, I think we'll take it off from there. Thank you so much.
No, Tobina takes it over from here, not me. No,
I wanted it to hand over to him. You are the chairman of the employment and the section of the section of business law. So please go ahead, and then Tobina will round off. Thank
you. No worry, I'm here.
Okay. Just say thank you, everyone, for taking time to listen to us and rant and talk. It's been quite interesting, and I'll just to leave on this note. I'll be following on the last case you talked about. A decision in France last year. One of the top CEOs of one of the French telecommunication company was on a work trip and was in his hotel room with his mistress and passed on. The European French employment tribunal held that it was in the course of work and that the employer should pay him. I mean, so I'll leave it on that note. Turn it over to you.
I think also you left it very vague, because it would have been helpful to know what the man's job description as CEO actually entailed. You know, so
but then it was a French tribunal. What do you expect?
What do you expect from the French tribunal?
Oh,
so,
well.
I mean, it's interesting, because I think Falabi chose the right time or the right context to end the conversation. Safety, safe conditions of work. So I mean, it could have been in that situation that he was allowed certain excesses that perhaps endangered him, and then he's able to claim for it. So his family now, because he's able to claim for it, you never know. But I mean, before thanking you, I think it's important to make the point around employment law, something that I found quite interesting in my career, especially outside Nigeria, that you find that the first issue with employment law is the set of policies that any organization has that regulates the employment activity in
Can anyone hear?
No, I think we lost him a bit there. We lost him.
Okay. Hello. Okay, I think there is a bit of a problem with his connection over there. I cannot hear him again.
Mm-hmm.
But all in all,
I think he's trying to return. He has a little bit of
okay.
Okay.
That's part of the workplace issue that from your hand should have been taken care of. Locris.
I know. I know, Flori, thank you very much.
In terms of multiple,
That's all it is. That's
internet
all it is.
Okay, if we cannot, I think at this point, is it coming back? Or is it back?
It's trying to.
I think we can proceed to conclude. Okay,
No,
okay, yes, he's about to rejoin.
Yeah.
Tobena, can you hear us?
Also, I keep reading the comments and they keep saying we should be back. We should be back.
I mean, we'll have to
we've had
discuss
3 days
we'll have
running.
to discuss it.
So we have to have
No, we'll
another
discuss
comment.
it together.
I found it quite interesting and illuminating, and there are a lot of informed comments in the comment box
Yes.
as well,
Yes.
Yeah.
Okay, he's back on now.
Yeah.
which shows that the audience were really following and interested.
Yeah.
Okay. Can you guys hear me now?
Yes,
I can hear
loud
you
and
loud and
clear.
clear.
My apologies. I don't know what the hitch was or glitch was. Now, I was just making the point that, what I found in the course of my career is that the policies that a company makes that regulates the workplace is very important. And in most cases, creates a strict liability situation for them, where indeed, if the law requires you to have certain policies around certain work issues and you don't have them, the courts will generally view them as strict against the company. But the more important point, really, I think, is that the attitude of those who are actually in the human resource area or who manage people creates a lot of problems most times for companies. But you find that every company that knows what they're doing actually ought to retrain and train the people. So they have the handbook, they have all the policies, but then they have the people problem. You find that the human beings actually, the level of infractions you find in human interaction is massive. So for those who are employers of labor here, especially those in the legal industry, I think we should constantly retrain our people because attitude at the workplace is very important. Now, just to conclude, I would want to say a big thank you to all the panelists who have indulged us and who have indeed spent their time to help educate us on this very important area, which, by the way, is an area that traverses literally every industry. That's why it's really interesting. There's no sphere of activity that does not involve employment law in it. So the practitioners in this area make a lot of money because they get constant and frequent work, either as advisors or as litigators. But so just before I close, I would like to say a big thank you to my Lord Justice Kanyip, who was here on day 1 and day 2 of the training sessions, and who would indeed have been here if not for the fact today, if not for the fact that he's been traveling. Added a made a huge impact in the training and has helped elevate the discussion from the point of view of the judiciary. I'd like to thank all the other panelists. Mr. Godwin Omoaka, Senior Advocate of Nigeria, thank you very much. Very illuminating and incisive perspectives you brought to the conversation. Mr. Falabi Kuti, Senior Advocate of Nigeria, another good friend and brother. Falabi, I mean, it's amazing. I was very excited at the chemistry between you and my Lord Justice Kanye.
Thank you.
The way you were able to manage the question on time is very, very impressive. Thank you very much. And also for generally moderating today's session. I'll also want to thank Mr. Osobeku for his insights today. Thank you very much, Jose. Mr. Inam Wilson, I can see Inam. I know he had a court case this afternoon and he still made it back here. I mean, it's the type of enthusiasm that really, really motivates and inspires us all. Very busy person, especially at this time, I know Inam is, but to take time out to say we need to be part of developing our jurisprudence is really impressive. Thank you very much, Inam, please.
Thank you.
Then Mr. Oke, thank you very much, Oke, for your perspectives. It was quite interesting watching the back and forth between you and Godwin and Falabi. I mean, there has to be somebody in the room who really thinks that the judges are doing the wrong things.
I didn't say they are doing the wrong thing. Don't create problem for me at all, please.
But I'll leave it at that for now. So, okay, that was a joke, by the way. So,
I know.
So, thank you very much for the audience today. I mean, we've had probably 1,500 people log in today, and that's a huge, huge number. Thank you very much for logging in. I'll only just say that it is something that we must do often. We must promote knowledge, development, and advancement in our profession. Tomorrow, there's another session on law office development and management. We will have Mr. Tomini Owolabi of Olaniwa Ajayi as one of the facilitators, and also Mr. Chiko Biamu of Templars as another facilitator. So I hope to see you guys at 2 p.m. tomorrow. God bless you, and I wish you the best of the rest of the day.
Thank you.
Thank you.
Bye. Bye,
Thank you.
everyone. Thank
Bye.
you.
Bye.
Thank you. Bye.
Bye.
Thank you, everybody.